This week saw the long-awaited Speaker ruling by the Speaker of the House of Commons regarding the Afghani detainee document issue. I'll put a link in the box if you want to read the full Speaker's ruling in the Hansard, but I wanted to give a quick commentary on it because I think it's somewhat important to see what's going on. It more or less was what was expected. It was really a speaker's ruling on three different issues. The first one probably got the most attention. That is the release of the documents by the government to the Commons. The other issues I think are important as well. The really interesting ruling, the interesting part of the ruling that I wasn't expecting was the ruling on the letter which was written by a assistant deputy minister to the law clerk of the House of Commons, claiming that Parliament's privilege to compel members wasn't absolute. I personally thought we may have seen a prima facie contempt on that. Prima facie contempt and prima facie contempt are, one's plural, the other isn't, are really what happens when the Speaker makes a first ruling on whether or not there's grounds to proceed with determining whether someone's in contempt of Parliament or whether the breach of privilege has occurred or not. What I found very interesting about the ruling, though, is that it found that that wasn't a prima facie contempt. And what it in fact found was that since it was written that the only way it would be a prima facie contempt is if it was used in some way to intimidate witnesses. This leaves a door open, though, to a second ruling of the prima facie contempt if the letter was somehow used either by the government or others to intimidate witnesses from giving full and complete answers before the Commons Committee investigating the Afghani detainee issue. The other thing I found very interesting about the Speaker's ruling is, as far as I'm aware, it's one of the first times it's happened in Canadian history, but the ruling hasn't fully been realized yet. If there is a case of prima facie contempt found, the prima facie contempt takes precedence over any other business in the House. What the government said, what the Speaker said to the government and the opposition is, get a compromise together. You have 2 weeks to do so. If in 2 weeks you can't, then we'll talk about motions. The motions which could be entertained are very interesting here because we're entering grounds which are very rare in Canadian history. So if in 2 weeks we don't see a compromise, we may see a very interesting Speaker's ruling. The one part of the Speaker's ruling which I found very interesting, and most people probably didn't even notice, was that there was a ruling on whether or not the House can even judge its own affairs. Now, the Canadian Constitution, in that video I talked about the different sources of Canadian parliamentary law and practice, and one of the sources which I did talk about was a few acts in Britain relating to Parliament and the monarchy. And one of them was actually mentioned, and that is the English Bill of Rights of 1689, I believe, which basically says the Parliament is supreme over any other branch of government, and that only Parliament can judge its own affairs. That, I think, may have been a little warning to the government, that if it was to go to court or ask a reference question to the Supreme Court, probably wouldn't be a good idea because Parliament cannot ultimately judge its own affairs. Parliament is supreme. Which isn't fully true in Canadian context, but it's mostly true. I really recommend everyone watching the Speaker's Ruling. It's about 45 minutes long. I've watched it about 3 different times, and every time I get something else out of it. Now, the Speaker's Ruling, I'm like I said, this video is going to be very short because most of it speaks for itself. But I think the one part of the Speaker's Ruling which really spoke to me was at the very end, and I quote from Speaker Milliken. "The House has long understood the role of the government as defender of the realm, and its heavy responsibilities in matters of security, national defense, and international relations. Similarly, the government understands the House's undoubted role as the grand inquisition of the grand inquest of the nation, and its need to complete and accurate information in order to fulfill the duty of holding the government to account." The Speaker goes on to rule, "But the fact remains that the House and the government has essentially an unbroken history of some 140 years of corroboration and accommodation in cases of this kind. It seems to me that it would be a single great failure for us to see the record shatter in the third session of the 40th Parliament because we lack the will or the wit to find a solution to this impasse." End quote. I personally think that's very true. And I think that constitutionally it probably was the best thing to do for the Speaker not to entertain a motion of contempt, which he can at any time. If there were to be a breakdown of the negotiations to such an extent that the Speaker felt that one side was delaying, the Speaker could at any time entertain a motion. And I think that we as a nation want more than that. We don't want that. We want this issue to be resolved, and we want it to be resolved in accordance with our Constitution and laws. In the Speaker's Ruling, there's a variety of sources mentioned, and I think the one thing people often forget, and I just want to say this in closing, is that Speaker's Rulings are kind of like a court ruling. There are a variety of authorities on the Canadian Parliament which speakers use. Yes, we have a written constitution, but there's very little about the privileges of Parliament in the written constitution. There's section and passing reference in Section 18 of the British North America of the Constitution Act 1867 or the British North American Act. If you prefer, saying that Parliament has rights similar to that enjoyed by that of the United Kingdom, but there's very little elsewhere to discuss that. And the reason why is that our Constitution understands that we as a nation need a flexible Parliament, but one that is rooted in traditions and one that is ever evolving. We have standing orders of the House of Commons, but we also have a great body of knowledge from across the various other governments which shares our system of parliamentary democracy to use. And it is my hope, as Speaker Milliken ruled, that we will look elsewhere in the world and find an appropriate compromise to this situation. I don't want to see anyone in contempt of Parliament, but we need to realize that Parliament has a role, as does the government. So that's my commentary on it. short and sweet. Well, 10 minutes long, not either short or sweet. I hope everyone has a wonderful week, and I'll probably be back with new videos next week. I don't know what I'm doing.